There you are, Mr. Musto.
Good morning, Your Honor.
I think you're on mute.
How's that? Is that working? No.
Coming through here, okay.
How about now? Is that working?
I can hear him.
Yes, I can hear him too.
Yep, we have them loud and clear here at Center Court.
Give me a second. I'm going to try to get my sound going.
Okay.
Sorry.
Test for Judge Northcutt, test for Judge Northcutt. Test for Judge Northcutt, test for Judge Northcutt.
I hear you now. Okay.
Very good.
Sorry about that.
No.
Mr. Musto, you can start whenever you want.
Thank you, Your Honor. May it please the court. Good morning, Your Honors. Anthony Musto on behalf of MKD, a juvenile who was found guilty of a crime that not only did he not commit, but one that he could not have committed. I would like to reserve 5 minutes for rebuttal, if that's acceptable with the court. The reason MKD could not have committed the crime, which was fleeing or eluding an officer, is that that crime can only be committed by the operator of a motor vehicle. And under the facts of this case, MKD cannot be said to have ever been an operator of a motor vehicle as that term is defined by statute.
Wasn't there something in the record indicating that he actually put the car in reverse before it came in a collision with the officer's car?
There was indeed, Your Honor, but that did not occur until they were in a parking lot. And the definition of operator reads, any person who is in actual physical control of a motor vehicle upon the highway. And those are the key words here with regard to whether MKD was ever, in fact, the operator as that term is defined by statute. The facts of this case are undisputed that the police were seeking to stop the driver of this vehicle, who was not MKD. MKD was in the back seat while it was on the road. They went, they followed this individual who had an ankle monitor, so they knew where he was going. He pulled into a parking lot. He stopped the car. He pulled into a head-in parking space, stopped the car. At that point, MKD—
And Mr. Musto, are you referring to, under the definitions of 316.003, the definition of street or highway under subsection 89A?
I am referring right now to 316.00353, which defines an operator. And it says—
Okay, right, but I think the thrust of your point is that it's not a highway, right? The parking lot's not a highway. Okay, and so if we look at 316.003 subsection 89, it defines street or highway. And I guess my question is, are you relying on subsection A of subsection 89?
I am relying on subsection A as well as 316.00397, which defines traffic.
Okay, and so and forgive me for the question, but why is 89 subsection B not appropriate here, where we're talking about private property?
Because subsection B refers specifically to ways or place used for vehicular travel, which is very similar to what is in A, which brings us to the definition of traffic, which again refers to for purposes of travel. A parking lot is not for the purposes of travel. It is for the purpose of parking. That's why we call it a parking lot. And therefore, these definitions do not fit. Now, I
And
will.
when you say that, are you relying on any statutory definition as far as vehicular travel?
I do not have a definition of vehicular travel, but I would suggest that inherent in parking is the lack of travel. And I would also.
Well, you have to actually travel to get to the spot to park.
That is correct. But if we,
Okay.
but the wording says that it has to be for purposes of travel. So any travel that would occur there would be incidental. The parking lot is for purposes of parking.
I don't
So-
see the word purpose. That's in subsection A. Subsection B doesn't have purpose. It says used.
It says used for vehicular travel. However, the word traffic that is defined in 00397 does refer to vehicles as well as other herded animals and so on, while using any street or highway for purposes of travel. And that the existence of subsection 97 here is what differentiates this case from the cases relied upon by the state. The state has cited two cases that hold that under certain circumstances, the offense of driving with a suspended license can sometimes occur in a parking lot. But those cases rely on a definition that is contained in 322, because 322 is the statute that deals with driving with a suspended license. We are under 316. Now, the provision that you and I just talked about is similar to the one in 322 and superficially appears to be the same. But the difference is 322 does not have a definition of the term traffic, whereas, as I just quoted to you, 316 does. Therefore, interpreting 322, courts are free to interpret traffic as they deem appropriate because there is not a statutory definition. In 316, however, you are bound by the fact that it must be for purposes of travel. And therefore, I would suggest to you that a lot, although it may incidentally involve some travel, would not be one that is for the purposes of travel. Also, I think it is important to realize that even if we are to look to the logic of this cases cited by the state, this particular parking lot does not fall within the definition. The state cites two cases, Mattingly and Tucker, each of which state the general principle, but they don't go into the reasons behind it. The reasons behind it are set forth in a case that each of those cases cited and relied upon. And that's State v. Lopez, 633 Southern 2nd, 1150. And in that case, which established that driving with a suspended license can occur in a parking lot, the court referred to the fact that roadways and parking areas in malls, industrial parks, and similar areas cover large areas of heavily traveled roadways, and police must have authority in those areas, which makes perfect sense. If we have a big shopping mall that's got a Neiman Marcus and it's got a Nordstrom's and all this, well, look at that parking lot. Yeah, they've got lanes of traffic. They've got stop signs. They've got pedestrian walkways. They've got left turn lanes. They may have stoplights. Look at what we have here. And it's perfect because we have a video here. We can see exactly what this is. And what it is a series of parking spaces that you pull off the road and head into. That's all it is. It's in front of an apartment building. Apartment building is a long, straight building. It's 2 stories, but the only doors are on the ground level. So it's apparently 2-story apartments. You might call them row homes or townhomes or whatever. And all you do is you pull into those parking spaces. And the distance, I would say, estimating if someone is in one of those parking spaces from the rear of the car to the road is maybe a car length, car length and a half. There is no traffic on these roads. There is in this parking lot. There is none of the things that go with the type of shopping malls that are the basis for the cases that the state has relied upon. So therefore, I suggest to you that number one, 316 does not apply to parking lots, period. Number two, to the extent that it applies to parking lots, it does not apply to this particular parking lot.
Can I
Alternative,
ask you the question? I think that the state is offering as the whether or not this issue was preserved at the front end of this case at all. And if it hasn't, why are we talking about it?
well, first of all, it has been. And second of all, I'll tell you why you would be talking about it even if it hasn't been. I believe the state's argument is based on a misreading of the record. The state cites to pages 43 and 44 in saying that in the motion for judgment of dismissal, the only thing that was argued was whether the actions were willful. That was the initial motion for judgment of dismissal. That was at the close of the state's case. It was an initial motion for judgment of dismissal. The defense then rested. The court colloquied MKD to see if he wanted to testify. He did not. And then I refer you specifically to page 48 of the record. At that point, counsel asked for permission to merge his second motion for judgment of dismissal with his closing argument, and the judge said that was okay. Therefore, the arguments that came after that were offered both as part of a motion for judgment of dismissal and as a closing argument. The state only refers to the initial motion for judgment of dismissal. And in that second motion for judgment of dismissal / closing argument, the counsel argued that there is reasonable doubt here that at the time these commands were given, MKD was the individual operating a vehicle on a street or highway. And then goes on to say, and in addition to that, and then goes into the willfulness argument that the state is setting forth. So I suggest to you that the state may have misperceived the fact that the closing argument was also a motion for judgment of dismissal. Beyond that, to get to your second question, Judge, if it's not preserved, why are we talking about it? The reason would be that even if this is not preserved, it constitutes fundamental error. The Florida Supreme Court in the FB case that I cite points out that if the evidence is totally insufficient as a matter of law to establish the commission of a crime, then it constitutes fundamental error. It constitutes a violation of due process. And I suggest to you that if this is, in fact, as I started my argument, a crime that my client could not have committed because he was never an operator, then that falls directly within that definition, and therefore it constitutes fundamental error. So whether it is preserved or not, it is a basis that requires reversal. To move on, Judge Case, to the point that you brought up earlier about my client putting the car in gear. This did happen. Of course, you only reach this if you reject my argument relating to the definition of operator. But the facts of this case show that MKD did not, in fact, flee. He thought about fleeing. He made preparation to flee by putting the car in gear, but he didn't flee. He stopped. He changed his mind. This is like someone getting a gun to go rob a bank and then saying, no, I don't think I'm going to do it. Now, the car did move, as you noted, Judge Case. However, the facts here are undisputed that that was not a matter of MKD's volition. We know that because, number one, we have his own statement where the officer says, well, why didn't you put it back in park? I didn't put it back in park. No, my bad. I meant to put it back in park. But we also have that corroborated by Officer Hogland, who arrived at the scene while the car was moving and saw there was nobody in the seat. If he was trying to flee, he would have certainly stayed in the seat. And by Officer Finneran, who said that the movement occurred while the car was going. The fleeing must be willful. What we have here at most is perhaps careless fleeing or negligent fleeing. At best, it is not willful fleeing. Once my client saw the police officer, he stopped and did not continue to flee. And I refer you specifically to the Creed case. I suggest to you that we have even stronger facts. That was a situation where a driver was being followed by the police. He pulled over, got out of his car, and started to run. The police came up, identified themselves verbally and by their uniforms, and he stopped. He was convicted of fleeing and eluding. The appellate court said, no, that cannot stand. Because once the officers identified themselves, he stopped. Our facts are stronger because in Creed, Creed was in fact the driver. He could see that the car was being followed. My client was in the back seat. There's no proof that he knew the car was even being followed. Number two, Creed had just pulled a gun on somebody. Therefore, he had reason to believe he was being followed. My client did nothing wrong, therefore had no reason to believe he was being followed. Three, in Creed, the officers verbally identified themselves as officers. That did not happen here. Four, in Creed, the officers made themselves visible to the individuals. Here, the officer positioned himself at the blind spot, presumably for his own protection, and I don't blame him for that, but it was at a spot where people would not ordinarily see him. The facts are clear that once my client turned around 135 degrees from facing front in the driver's seat, saw the officer, that's when he stopped. Therefore, for each of these reasons, he was never an operator, he did not flee, and the others that I have talked about, this case should be reversed. Thank you, Your Honor.
Thank you.
Good timing, Mr. Musto.
Thank you, Judge.
Mr. Wintercorn, Ms. Wintercorn.
May it please the court, Your Honors. My name is Alicia Wintercorn and I represent the state of Florida. Appellant's argument can be divided into two separate sections. First, the portion that is preserved, and second, the portion that is not. Addressing appellant's preservation argument, in the first motion for judgment of dismissal, this argument that appellant was not an operator under the definition of Chapter 316 Florida statutes was not included. Even viewing the closing argument and, as appellant phrased it, merged second renewed motion for judgment of dismissal, this argument was not set forth. Looking to the direct language in the transcript, defense counsel said that there is reasonable doubt that appellant was the individual operating a vehicle on a street or highway, and in addition to that, even if he was, and then continues on with a willfulness argument. He does not flesh out that the strip of the parking area is not satisfactory under street or highway. That argument is never presented to the trial court. And the trial court gave appellant or defense counsel at trial a second opportunity to speak after the state's closing argument. And if you look to that portion of his response, he again reiterates this argument that appellant wasn't the individual driving the vehicle. Again, this argument is not set forth that the portion of land that the vehicle was operated on did not qualify as a street or highway. For those reasons, the state does not believe this argument is preserved. Fundamental error was not raised in appellant's initial brief. Therefore, this court need not entertain a fundamental error analysis. Now, if this court chooses to entertain a fundamental error analysis, appellant cannot show fundamental error. Fundamental error in this context is, was there sufficient evidence that defendant committed any crime at all? And in here, defense counsel conceded below on page 49 of the record that appellant committed the crime of disobeying a lawful order by law enforcement. And the exact language that trial counsel used was, when talking about this lesser included offense, and I quote, "I believe at best the evidence supports a finding for that charge." And in that charge, he's referring to that misdemeanor lesser included, but not for fleeing and eluding. And so the state's position is that even if fundamental error is reached by this court, it cannot be, the appellant did not show fundamental error because appellant's trial counsel conceded that the state proved at least a crime occurred at all. Moving to the merits arguments of appellant's argument. Appellant argues that the definition of street or highway is not satisfied by the strip of area that the parking area where the vehicle was driven on, and the state respectfully disagrees with this. Looking to this court's analysis in Tucker, appellant is correct that Tucker does reference the 5th District's decision in Lopez. And in Lopez, it does talk about the heavily traveled areas. However, this court's decision in Tucker was based on a parking area in which this court described as a private gravel, dirt / road parking lot. This court did not elaborate that it needs to have any sort of sufficient level of travel in any sort of airport or a supermarket parking lot. Based on this court's decision in Tucker, and based on the fact that the definitions of street or highway under Chapter 316 is very similar to the definition of street or highway under Chapter 322, the state asked this court to apply its analysis in Tucker to the instant case and find that this parking area does satisfy the definition under Chapter 316 for street or highway. Moving on to appellant's second argument of whether or not he will.
And my similar question to Mr. Musto, are you dealing with, when is the state's position under subsection on the definitions of street or highway, is that under 89A or 89B?
Well, Your Honor, I believe that appellant heavily relied upon under 89A, which talks about, in his argument, for purposes of vehicular traffic. When looking at subsection B, it talks about having a county or municipality exercising traffic control jurisdiction over, over said way or place. And either definition, the state's position is that this parking area satisfies either one. I know that appellant heavily relied on subsection A and whether or not traffic was defined. The state does not believe that that argument has merit as to whether traffic is defined under 322, but not defined under, or I'm sorry, is not defined under 322, but is defined under 316, because here the parking area is very similar to the parking area that was contemplated in Tucker. And in Lopez, the court did talk about the public policy concerns of having law enforcement being able to enforce traffic offenses and traffic violations within these parking areas. Moving on to appellant's willful argument. So the state presented sufficient evidence at trial to satisfy what the element of whether appellant acted willfully in refusing to stop. And here, starting with the dash camera video, when you watch that video, you see the Detective Finneran's vehicle pull up. You can see as he's pulling up, the car is in park. The car is then placed in reverse. As the passenger side door begins to open, Detective Finneran exits his vehicle, guns drawn, and starts giving commands, "Show me your hands, show me your hands." As those commands are being given, the vehicle begins to reverse back. As the vehicle continues to reverse, these commands are continued to be given by Detective Finneran until the vehicle crashes into his patrol vehicle. Now, a close view of the video can show that when the vehicle is placed into park, the wheels are slightly turned to the left. And then once the vehicle is placed into reverse, you see the wheels slightly turn straight. The state's position is that this is further evidence of an intent to flee. This is further evidence that appellant knew that there were law enforcement officers behind him, because it appears that he is trying to maneuver around the vehicles that he knows are blocking him in at that time. This is coupled with appellant's own admissions and statements. Now, during the post-Miranda recorded interview, appellant makes multiple statements in agreement with Detective Finneran's questions. Detective Finneran says, "You were going to try to D me, right?" And he explains that that is street language for trying to flee, trying to get away. Appellant says, "I thought about it. I wasn't going to do that. That's why I got in the back." Detective Finneran interrupts him and says, "Well, you saw the gun pointed at you. That's what happened, right?" And appellant agrees, "Yeah." Appellant then goes on to agree that something like that, when he's questioned, "Were you going to drive off into the sunset?" Something like that, not really though. The conversation then appears to turn more casual until appellant learns that he's going to be implicated for this crime. And that is when he starts backtracking. "That's not what I meant. I didn't really mean it. I wasn't going to flee." But at that point, he's giving these self-serving statements because he's trying to get out of a crime. And any inconsistency in his statements goes to the weight of the evidence, which is a question for the trier of fact. That's not a question for the sufficiency of the state's evidence. And when you view the evidence in the light most favorable to the state has presented sufficient evidence that appellant acted willful in fleeing and attempting to elude, although maybe unsuccessfully in attempting to elude. because he did not end up getting away. Detective Finner also testified that he did see a person jump from the driver's seat into the back seat as the vehicle crashed into the patrol cruiser after he gave commands to stop. And then appellant admitted to Detective Finner and that he was the person that was in the driver's seat. Therefore, it's the state's position that the trial court did not err in denying this motion for judgment of dismissal, and that the state presented sufficient competent evidence for this to survive a motion for judgment of dismissal, and it properly went to the trier of fact. Being a juvenile case.
One
Yes,
more
Your Honor.
question for you, if you don't mind. Does it matter that the police cruiser's lights and sirens were not or never activated? Does that make any difference in the argument here?
No, Your Honor. So there are different subsections under chapter 316.1935, which deal with higher offenses, more severe offenses that have to deal with lights, sirens, and insignia. And in the subsection 1, in which appellant was charged and convicted under, it's not a requirement that lights and sirens were activated or insignia was on a vehicle. All that matters is that appellant was given an order to stop the vehicle, and he willfully chose to either fail to stop or stopped and then kept going again in violation of that order and fled in an attempt to elude the officer. And the state has proved that, Your Honor. And if there are no further questions, the state will rely on the arguments set forth in its brief and ask that this court affirm. Thank you.
Thank you, Alicia.
Thank you, Mr. Winterkorn. Mr. Musto.
Your Honors, the state has argued today that fundamental error does not apply if you can find any crime in the record. That is not what FB says. FB says if the evidence is totally insufficient as a matter of law to establish the commission of a crime, it encompasses the crime charged. And if there's any doubt about that, look at the 2 cases FB relied on. In each of those cases, there was another crime. What this has to do with is a situation where somebody breaks into my house and steals something, and they're charged with taking my property. It actually belongs to my wife. Okay, that's encompassed in the charge. It's worth $80, but he's convicted of grand theft. That's encompassed in the charge. You can't go rooting around in the record and try to find something that the defendant was never put on notice of. In fact, if I had been the prosecutor in this case, I probably would have charged resisting arrest, but that would have changed the whole dynamic of the trial. The defense, for instance, might very well have moved to suppress the statement under those circumstances. And if you note, twice the officer says, I'm going to ask you questions, I'm going to interrogate you, but first I'm going to read you your rights. So I think there was a very good argument here. They may have chosen not to do that because of the charge that the state chose to present. Second of all, the state talks about the fact that the wheels were turned. They remain turned. If you look at the video, you see the car backs like this way when it goes into the police cruiser. So that argument is consistent with exactly what was going on here. Third, the fact that MKD made these statements, the state is saying they were self-serving. There's no contrary evidence. This is the only evidence in the record. If the state had something to contradict it, they could have contradicted it. And in fact, Officer Hoagland said, when I pulled up, and you can see when he pulls up, the car's in motion, there was nobody in the seat. And also, it would make no sense if you're fleeing, why would you jump in the back seat? If you're fleeing, you're going to flee. So none of that actually falls into place. The state also argues or refers to as I believe her words are, as appellant phrases it, merge the argument. I refer you to page 48, where counsel says, I will merge second JOA, and closing, the court says yes. So the court authorized this. The trial court authorized it. It was allowed to proceed that way. Counsel also says that trial counsel did not flesh out the argument. Well, how many JOAs are fleshed out to the extent that an appellate brief is? You make the court aware of what element is not shown. The court did that, made that element, and so on. As far as the parking lot, it's the state's burden to prove each of the elements. The state has to prove that this is a parking lot that falls within that definition. The only evidence presented was that video, and if you look at that video, there is no way it falls within it. Therefore, this case should be reversed. Thank you, Your Honors.
Thank you.
Thank you both. In order to leave our virtual courtroom, you need to click the button on your Zoom screen that says leave. Okay, and our next case is the Renwicks versus Murray Homes LLC. Oh, there you are. Okay, you can start whenever you're ready.
Morning, Your Honor. May it please the court. My name is Joseph Herbert and I represent the appellants, Glenn and Deborah Renwick. I would